and she was formerly the director of Kingston Legal Aid Clinic and the senior legal counsel for the Fair Trade Commission. She has also published 3 books: The Trial by Paper, The Law of Dangerous Drugs in the Caribbean, Cases and Materials, and The Law of Firearms in the Caribbean, Cases and Materials. She is presently an associate tutor in the landlord and tenant at the Norman Manley Law School and the senior parish judge for the parish of St. Catherine. Her topic today is the Child Care Act and the UN Convention on Rights of the Child. I can see her first slide. So the Child Care and Protection Act, many of us as pediatricians and medical practitioners, we are intimately aware with it, but all of us have a role to play in the rights of the child and reporting if we think these rights have been, abused. So I'm sure there will be many questions from this session. So you can take it away, Judge Aline.
Hello, good afternoon. You're hearing me?
Yes, we're hearing you. It's not in slideshow though.
Okay, just a minute, please. Right. You can see the slides now?
We're seeing the slides, but it's not in slideshow. It is in slideshow now.
Okay, thank you. Good afternoon, everyone. Thank you for the invitation to present today. And it's on the Child Care and Protection Act 2004 that came into being 2004, and the United Nations Convention on the Rights of the Child 1989. Now, the important aspect of these two, well, the Child Care and Protection Act and also the United Nations Convention is to promote the best interest, safety, and well-being of children. And in that, we recognize the child services, and the child services are to recognize the differences among children in their development. Now, a child is understood to be under 18 years old. This is stated in both the Child Care Act and the United Nations Rights of Convention for the Rights of the Child. So the best interest of the child is the paramount consideration in everything that we do. The Office of the Children's Advocate is established to enforce the rights of the child. I must remember that the child must be able to express his or her views on a custody matter involving him or her. So if a matter of custody is before the court can ask the Office of the Children's Advocate to contact the child to obtain their views about the custody proceedings. And Article 12 says in the convention, says that the states parties must assure to the child that they can give their views freely in all matters affecting that child. And of course, it will have to it will be linked to the age and maturity of the child. So when dealing with custody matters, sometimes we do take the child into chambers sometimes and speak to the child to determine his or her views. And also you can give legal aid for an attorney to represent the child depending on the circumstances. Now, what's important is that persons can make complaints to the Children's Registry about the child being abused. So if you have information about abuse or neglect and you do not report it, then you can be liable to be convicted. And of course, that will include the doctor. So when they are examining children, if they're of the view that there's some amount of abuse there, then they need to report it to the Children's Registry or even to just the police, and they will proceed. In many cases, the children sometimes complain to the parents, particularly the mother, about sexual abuse and nothing is being done. Well, perhaps the parents will know why if they do not believe the child, or if they have any reason not to report it, perhaps financial dependence on their partner, I don't know. But that is an offense. We're not to be fact finders as to how this occurred. If it indeed is true, especially in situations of sexual abuse. And of course, you must report the matter, can be convicted to a fine of $500,000 and or 6 months imprisonment. And we do have parents and other persons before the court charged for not reporting the anything that the child told them, especially about being sexually abused. Now, Article 18 of the United Nations Convention did say that the state parties must use their best efforts to ensure recognition of the principle that both parents have responsibilities for the upbringing and development of the child. And so the Maintenance Act of Jamaica places an obligation on both parents to maintain their children. And Article 19 of the United Nations Convention is also appropriate in this respect because it states that states must take all appropriate legislative, administrative, social, and educational measures to protect the child from all forms of physical or mental violence, injury or abuse, neglect or negligent treatment, maltreatment or exploitation, including sexual abuse. So states must ensure that there are legislative and administrative measures there. And it is my view that in Jamaica, we have ensured that that is done with the Child Care and Protection Act and other legislation. So children are entitled to be protected from abuse, neglect, and harm or threat of harm. You cannot cause the child any unnecessary suffering. I remember you cannot assault the child, as in Section 9 of the CCPA, the Child Care Act, will be breached and you can be imprisoned or fined. Now, where a child is brought before the court as being a child in need of care and protection, and if there's any reason to believe that the child has been abused, the court may make an order, and this is where the doctors come in, requiring that the child be medically examined. This is where the pediatrician will come in for purposes of determining what steps ought to be taken in relation to the health and medical treatment of the child. And if that order is made, the pediatrician will have to carry out that order and medically examine the child. And importantly to know, no proceeding shall be brought against a medical practitioner for anything done in accordance with this section. And Section 22 of the Child Care and Protection Act, again, we'll need the doctors here because where a person is charged with or convicted of an offense, against a child, and that person is the offender, and they've listed like offenses against the Persons Act, like Section 40 and 48, carnal knowledge of girl, and so on, of the children, indecent assault. And when it concerns possibly transmitting a disease to a child, the court may make an order requiring that person, that alleged offender, to submit a medical examination and testing for the purpose of ascertaining whether such person is a carrier of a communicable disease. So again, we'll ask the doctors to assist us if the child has been allegedly, I must say allegedly, if there was any carnal knowledge of the child. And we'll ask the doctors to medically examine the child to see if there's been any STDs. The police can remove a child to a place of safety and bring the child before a children's court or a judge of the parish court in chambers within 48 hours once they get the information that something is wrong with the home that the child is in. And Article 20 of the United Nations Convention states specifically that a child temporarily or permanently deprived of his or her family environment, there must be that state must ensure that there's protection and assistance. So the state parties must, in their national laws, ensure alternative care of the child. And of course, such care will include foster placement and our places of safety and so on. And they have to ensure the continuity in the child's upbringing. Now, the children's homes are to be licensed by the minister, and that is in the Child Care and Protection Act. And in the place of safety, the child has a right to be fed, clothed, nurtured, consulted again about and according to the child's abilities. The child has to express his views about significant decisions affecting that child, reasonable privacy, education, and the child must be free from corporal punishment. by the caregivers. And of course, they must receive medical and dental care. So that is in accordance with the United Nations Convention, which will say that we have to ensure that if we take the child from the home, that the places of safety will be able to adequately look after that child. Now, when a child is arrested, now, the Child Care and Protection Act also deals with when a child is arrested. You must state that Section 63 says that no child under the age of 12 can be guilty of an offense. And the United Nations Convention did say that we must state under which age a child cannot be guilty of an offense. And always we keep saying, when dealing with a child, the best interest of the child is paramount. And if the child has reached the age of 14, he can be offered bail. And if he's so unruly and he cannot be so committed safely, the child will then have to be detained. And then if he's so unruly, probably to an adult correctional center. But we always ensure that the child is in a place of safety, a juvenile correctional center. So when the child is charged and brought before the court, the child's parents or guardian is required to attend court unless it's unreasonable. So we always ensure the child's family is also there as much as possible. So Article 37, you look again at United Nations Convention for Rights of the Child. Article 37 states, the states party shall ensure again, no child shall be subjected to torture, any cruel, inhuman, or degrading treatment, and no child shall be deprived of his or her liberty unlawfully or arbitrarily. And an arrest or detention of a child shall be in conformity with the law. And every child deprived of liberty shall be treated with humanity and respect for the inherent dignity of the child, and in a manner which takes into account the needs of persons of his or her age. So there is a lot of emphasis on ensuring that even when you deprive the child of his or her liberty, that they are well looked after. And it must be in the child's best interest for that to be done. And the child has the right to get legal and other appropriate assistance, and can also challenge the legality of the deprivation of his or her liberty. Now, Article 40 also states the state parties recognize the right of every child. If a child has been accused as having infringed the penal law, then you must ensure you still promote the child's sense of dignity and worth. And there's our children's court that we have here. Ensure that is why we ensure, I must say, that the children are being separated at all times from the adults. In the children's court is separate. We try to ensure that the children's court not there at the same time at the same place and time with the adult court. And also when children come to court, the child is not allowed to be in court unless the matter that we're dealing with concerns the child. So it's stated in the Child Care and Protection Act that the child is not allowed to be in court unless the matter we're dealing with concerns the child. So we try to separate the child and the adult as much as possible. And so every child that is presumed innocent until proven guilty, and the child is to be informed promptly of the charges against him or her, and to have the matter determined without delay by a competent, independent, and impartial judicial body in a fair hearing, according to law. This is what the United Convention for the Child's Rights said. And not to be compelled to give testimony or to confess guilt, or if considered to have infringed the penal law, then we will ensure that usually if there's a pronouncement of guilty, then we ensure that there are proper children's report being made to explain the entire circumstances of the child before the sentencing. So the state parties must ensure that, as I said before, the establishment of a minimum age below which child is presumed not to have the capacity. And remember, we said in our Child Care and Protection Act that will be 12 years of age. So the children's court is established by it, and we must, in sentencing a child, a report must be had of the child's surroundings, his school record, and so on. And it's a duty of the probation officer to do a report on the child. So no charge against a child shall be heard by any court which is not a children's court. But of course, we had a case that just came out. We have scheduled 4 offenses, I must say, that deal with very serious matters like sexual offenses, rape, burglary. It came out that those cases will have to be dealt with by a higher court, murder, and so on, in those circumstances. So although it said no charge against a child shall be heard by any court, which is not a children's court, but we have the Schedule 4 offenses, and those matters we have to commit the child for a higher court to deal with those matters. So I know this is really for a public session, so that's just my introduction, and I'll await if anyone has any questions concerning it. I would say that in the parish court, we really deal with indecent assault matters against children and so forth. That is when it comes before. When the person is an offender, then and wounding a child and so on, cruelty to a child. When you're cruel to a child, you can be charged. Also, I must mention here about the begging that we see on the road. All of that is against the Child Care and Protection Act. It ought not to happen, and the children should be placed in a place of safety if the adult is not properly taking care of the child. And the child must ensure, we must ensure that the child is educated. That is an offense if the adult who is in charge of the child does not ensure that the child has good education. And we always encourage the ladies that, you know, or whoever has whoever has the custody or the care and control of the child. So if you're having problems, you know, you can always let the government know. There's the path program that you can go on, and you can also bring the men and the women bring their partners to court for us to do a maintenance, to do the maintenance to ensure that they are contributing, so the person who has care and control of the child can still adequately look after the child. So that is very important. So I'm going to stop here and hear if there are any questions.
I'm not. Let me see.
You're hearing me?
Yes, I'm hearing you. I'm looking at
Yes.
Q&A. I'm not
Yes.
seeing any questions. I'm actually a little surprised because the Child Care Protection Act is something that, you know, we deal with every day.
Yes.
I do know recently that, is it true that issues of guardianship no longer go through the children's court?
Right. There was a case that came out, JC versus the advocate, and that dealt with it in terms of whether legal guardianship can be. And it just has to deal with, in particular, how the section was worded, really. And the Court of Appeal made a decision in that respect, that it will go to the Supreme Court. The Supreme Court has the inherent jurisdiction to deal with that.
Okay, so in our setting, sometimes the issue of guardianship, it needs to be dealt with very fast.
Well, it is not just a white thing, you know. I think when you look at the case, and I don't really want to go deep into case because it's not here with me now, but when you look at the case, it depends on who. If the parent, in that case, the parents, I think, had died, from what I remembered and what I recalled of the case, and they did not, the maternal cousin, they did not tell the maternal cousin that the maternal cousin was taking care of the child, but they did not actually give her guardianship, formalized it. And so that was a problem. But under the act, you can indeed, if you are alive, once you can say that this person can be the legal guardian of your child. But that was a specific case in which both parties had died, and the act did not really didn't speak to both parties. parties having died and not formalizing the legal guardianship
Right.
of the child.
So let me ask it formally, Judge Alain. So we have instances where the mother is dead or the mother has a mental illness and is unable to give consent for our children, and we don't know, we can't find the father, and we have a medical
Yes.
procedure that we may need consent for, and somebody is looking after the child, because it's so very common in Jamaica for the child to grow with the auntie or the grandma, but they've
Right.
not gotten that formal guardianship. So is the act of them taking care of the child assuming formal guardianship,
Yeah,
or do
well,
they
in
still
that
have to
case, you
go?
can go for guardianship, but what they're saying is the family court has no jurisdiction to grant an application for legal guardianship and custody where the child has no living parent. The provisions of the act, which should not be well. And the family court has no jurisdiction to appoint a legal guardian where the surviving parent is unknown or mentally or medically unfit to parent the child. So you will have to go to Supreme Court. Not to say you can't get it, but they said in
Okay.
the case that you have to go to the Supreme Court to get that done.
It's just
So
that
you're
in
not
our
entitled if
country, everything
both
takes so long.
Yes, well, I think that we're really pushing hard to get things done much faster now. So yes, I mean, I must say the parish court is much quicker to get things done in terms of our, because we're the people's court and how we move. But in the Supreme Court also, you can get it done much faster now. I don't think it's taking as long as before.
So somebody asked,
But you have to move quickly, because what happens I find is that persons have the child for so long, like in this case. And then when the child is, I think, but 16, 17, then you're making a move, And they had a guardian of the child, as you said, when the parent is alive, but you don't do anything about it. So we need to be more proactive immediately. As you realize you cannot manage, you just do it under our act and come to the parish court and get it done. In this case, he died, she died, all the time the maternal cousin was dealing with the child, and then you wait so long, and then again, the person waits so long until the child is about 16, I think, or 17, and now you're saying, oh, I'm applying. You didn't do that all the time when the child was small. So you have to encourage them to move fast. Once the parent is alive and you can find the parent, move quickly. Don't wait until all those, all those problems arise. And then when you're finally going, you have to go Supreme Court.
okay, thank you so much, Judge Aline. I do see a
Mhm.
question here. What legal protections are afforded to pediatricians who report suspected child abuse in good faith, even if the report is then later unfounded?
Yes, you are properly protected. There is no, if once you report it in good faith, once you see that there is in fact, you have to, by the way, you don't have a choice really, or you see, if especially speaking to the child and you said how you come by this and the child tells you and you don't report it, then you can be in trouble yourself. So in terms of being brought before the court, it's not just the mother or whatever. So you have a duty actually to do it. And then you're protected once you do it in good faith. If you said, oh, you come by this and they said, daddy, mommy, whatever, you have to move. That is what the act says. It's just like the mother or who doesn't believe that the child was molested by her partner or whatever, because the child will say when things get out of hand and they go to the child and they said, but I tell the doctor, I tell the person, then the police hearing all these people who you tell and you didn't do anything and they'll come free. They can't do that because you were alerted.
Okay, so
Especially by the child, especially if the child tells you.
okay, Dr. James Paul has a question. In cases where the parents have died and a grandmother or I guess another relative wants to assume custody, how do they go about that?
Well, you can do, as I said, the application for legal guardianship, and also we have the Adoption Act. Remember, we can still do adoptions. So you can go that route, but you can do the application for legal guardianship and seek to get to be the legal guardian of the child, to look after the child. But you can go to an attorney at law, look at all the different legislations and tell you how best to proceed, how quickly it's best for you to be able to have care and control of that child. Because a lot of things I find in speaking to persons is that they can't do certain things unless this is formalized
Okay.
and legalized. And another
Um,
thing too, sorry, we need to encourage, I must say, the children, they really need to have, and it's their right, and I keep saying that, we need to have the children's names on their birth certificates, right? So we need to encourage that. I will ask the pediatrician. I think they always say that the persons in charge of the registry there, the birth registry, are asking us and asking everyone to try and ensure the father's name is on the children's birth certificate. Very important.
well, I will say that what if the mother doesn't know the father in that sense?
Well,
What do
she
you
can
mean?
do a declaration of paternity to
Okay.
have the and we are seeing that now, where no shame at all. She brings the two males who she has been having intercourse with during the time of the conception of the child, and we send them all for the DNA testing. And I must say, the women are standing up sometimes now and saying, I will pay for it. And then we determine who is the child. We made that declaration that so-and-so person, Tom Adams, is the child, and then they send it off to the registry there, and then they put the father's name there. So we do encourage them, once you see that, try and get it is, we're seeing adults trying to do declaration of paternity, because I think for children it's hurtful. And then you have a birth certificate with blank, father blank, like I say, it's not nice. So we really try to encourage them to get the father's name on the children's birth certificate.
Okay, so another thing that we see commonly is refusal of treatment. How do we as medical practitioners and pediatricians handle that, especially in a case where we think that the treatment is needed because the child's life is at risk or their health is at risk, and the parent is refusing treatment or refusing admission to the hospital?
Well, they remember the children have the office of the children's advocate, So I would suggest that in those circumstances, you can call them and ask them for their advice how to deal with it, because they can also remember, in our position and throughout the act, these children have rights to their attorneys, their own attorneys, and we have the office of the children's advocate. So if you have that problem, you can contact them, and they will guide you as to how best to deal with that situation, how they will intervene, and so on. Depends on the circumstances within the parameters of the law. But the Office of the Children's Advocate, I'll advise that you really call them and let them know whatever problems you're having that you think is against the interest of a child.
Okay. Another question is, what support systems are available under the Act for children who are identified as being in high risk or abusive environments? Now, I know the hospital is a place of safety, and it can
Yes.
sometimes house children for months, but that is not a long-term solution. So
Yeah, but remember that you do alert either the OCA, the police will take them into a place of safety, as I had said, and can bring the child before the family court, the children's court, within 48 hours. So it's always good. The police are always there if you notice that the child is really being abused or neglected and so on. As I had said, you just alert them, and they will bring the child before the family court or the children's court, and the children's court will do a thorough investigation and make the necessary orders, and can in the meantime place the child in a place of safety and so forth while the investigations are being done. And as I said, the place of safety, you have to ensure that the places of safety are really places of safety for the children in terms of their education and so forth,
what in terms of the Child Care and Protection Act, what is the age Some of us may already know the answer to this question, that a child is considered capable of giving consent for medical treatment.
Oh, consent. Well, for medical treatment, that is an interesting one. I didn't think about that because, of course, I'm not in that area. But I know that throughout, if you go to the children's advocate, I mean, as I said, when you look at the act, you see that the child's views are important concerning what is in the best interest of the child. And the OCA can step in if you're of the view that and speaking to the child that there's a problem between the child or the parents are being unfair. The Office of the Children Advocate, that is where they are. They are there for the children, you know. They are there for the children. So any problem you have, you just call them and they're going to guide you as to how to deal with those matters.
Okay, thank you, Judge Aline. I know that we could have a whole conference just speaking
I
about
know.
the rights of the child and,
Yes.
various things and various little nitty-gritties in the law. But thank you
Yes.
so much for sharing with us
Thank
this
you.
evening. I really hope that it was helpful for anybody.
Yeah.
I know we still have a little time. I see one more question in the chat. Let me see. Dr. Richard Dawson is asking, are there plans resensitization of the general population about the Child Care Protection Act? Because we know as medical practitioners, but I don't know if the John public knows that they can report, like if you are hearing your neighbor beating their child, that you should report.
Yes, yes, you can. Okay, I'm not sure because I'm not in that arena, so how the ministry or whatever, what they do to sensitize the public. I haven't been up to date with that. I am not sure about any plans that they may or may not have. But I think that well, I don't want to be unfair because, as you said, because I am in it. I'm of the view that everybody knows, right? And therefore, I can be wrong. You cannot assault a child. Perhaps they don't, because sometimes when the parent comes, and I have situation where the parent comes and they said, well, Judge, what must I do now? Bet you take, because I can't beat her. I am in the wrong. They're genuinely perplexed because that was the way they were brought up. How do I deal with this situation? They're genuinely perplexed about it. So, but all I deal with is I say, well, under the Act Section 9, you have abused her, whatever. And many times we just do, it's not necessarily that we will lock them up or anything. It depends on the circumstances and how terrible is the abuse, and the age of the child. And if it's a baby, I mean, that's so. And, depends on, it's a 14-year-old, a 15-year-old not coming home at night, you're at your wit's end. So all of these things are the different circumstances. But as I keep saying, the Office of the Children Advocate, that is why the government ensured that there's an office that speaks directly for all interests of the child. So I know they sensitize us, they usually sensitize us, and I am not sure what plans they have or what they're doing to sensitize the public, but I assumed, wrongfully I suppose, that the public should know these things by now, but probably I'm wrong. I don't know.
We are
It's
very
for the
well
ministry
aware
to
of the
do that.
Office of the Children's Advocate, and she has also spoken many times at many of our conferences.
Yes.
But I think that probably the wider public is not as aware, and maybe that's something that we need to advocate for. But it really has been a pleasure having you on the panel
Thank you.
Presenting to us.
Thank you.
For everybody, thank you for sticking with us to the end. For those who don't know, we have our banquet tonight at the Terra Nova, and I hear that there are still tickets available. So I hope to see some of you in your very beautiful dresses and your nice suits later on tonight. I think that is it for me. I don't think there are any more sponsor presentations. Let me check. There are no more.
No, I don't think there are any more presentations from the sponsors.
So we've finished with enough time for everyone to go and make themselves, ready for later tonight. And you can speak to any member of the exec, read tickets, because I hear there are still tickets available. Thank you so much.
Right. Thank you so much, Doc, for moderating, and thanks to all of our moderators, all of our presenters today, and definitely all the sponsors who came on to make this day a reality. What a day it has been. But the most important persons who joined us today, of course, were you, the attendees. Thank you so much for joining, for attending, for paying for CMEs. And we look forward, as Doc says, to seeing you at the awards banquet. Turnover All Suite Hotel. Honoree tonight is Dr. Leslie Gabe, and cocktails start at 7 and the dinner starts at 8. Tickets still available for 10,000 Jamaican dollars. And then, of course, tomorrow we would continue for face-to-face sessions, which will be held at the Jamaica Conference Center. That's it for Oldgate Solutions for today. CMEs will be sent out no later than 5 working days after payments have been confirmed with the PAJ and the listing shared for the CME certificates for today. Ladies and gentlemen, again, thank you so much. Have a wonderful, wonderful evening. Stay safe, and we'll see you at the next one. I see a question here. Will tomorrow be online? No, tomorrow is solely face-to-face.